Dr. Conway Blake is our next speaker. He LLB from University of West Indies, Cambridge LLM, where he came to first, which is not easy. A PhD also from Cambridge. He's based in Debevoise, London office, and member of their International Dispute Resolution Group, and also their Business and Human Rights Group. He's worked in Washington and in London. He has also lectured in public international law at King's College in London and has served as a consultant in international law to several NGOs. I mention Business and Human Rights Group because one of his publications is titled, and I confess I've not read it, and for that I apologize. It sounds interesting. It's Moral Damages in Investment Arbitration. So Conway is going to speak about arbitration in Pacific Island states. Conway.
Caribbean states.
Oh, I beg your pardon. I'm very sorry. And you have to allow me for my
yes,
origin.
Your origin.
Yes.
Good afternoon, everyone. It's a privilege to be here, and I know it's late in the afternoon, so I will try to be concise and prompt. I will be looking at international commercial arbitration in the context of the Commonwealth Caribbean. Justice Anderson and a number of other speakers before have addressed the legal developments in the Caribbean, so I don't have to draw a map. But I will be speaking about the Commonwealth Caribbean, so it's those countries in the Caribbean basin who, for various historical reasons, including being commonly former colonies of Great Britain, have common historical, cultural, economic, and legal ties. And the topic I won't stick to it. The topic I had was the promise of international arbitration. We did hear Gary extol the virtues of international arbitration, and in the panel before, we heard judges and practitioners speaking about the virtues of specialized courts. So for me, the promise of international arbitration, there still is a question mark, and that's one of the things I want to ponder, whether, what is the promise of international arbitration for small states, what can they get from it, but I will be using the Commonwealth Caribbean to illustrate that point. Historically, the Commonwealth Caribbean has, like many small states, developing states, had an ambivalence to international arbitration and arbitration in general. And this is evident, for example, in the present legislation that is in many of the Caribbean states. My state, for example, Jamaica, the Arbitration Act is a colonial statute. It's still based on the 1900 English Arbitration Act. I've yet to see another jurisdiction with that act. And there are a number of other Caribbean countries, for example, Trinidad and Tobago, that has, I think, a variant of the 1926 Act. Those pieces of legislation are not fit for purpose, I think it's fair to say, for international commercial arbitration, and even for contemporary or modern domestic arbitration. Caribbean states have gone through various exercises in domestic legislative reform. The question is, why haven't they reformed this? I think that it speaks to a level of ambivalence, including from practitioners. Last year, I traveled to Jamaica and we had a conference on commercial arbitration, and quite frankly, the lawyers were very happy with going to court. They didn't see the reason why. And of course, with eminent jurists like Justice Anderson, you could see why. They are quite comfortable going to court. Other jurisdictions, the second half, so there's a category that has the 1900 Act, and the second category of jurisdictions. And they're a bit more recent, and they are modeled on the 1950 Act. So it's fair to say that by and large, the majority of states have not upgraded from their colonial statutes. And I think that this is in part due to an ambivalence. This is not to say that international commercial arbitration doesn't happen in the Caribbean. If you go through the law reports there, particularly in the construction industry, there are a number of international arbitrations, arbitration clauses governed by Jamaican law, but subject to ICC rules. But you can see the difficulties faced by the courts having to marry ICC rules arbitration with a 1900 statute. And they have done an admirable job trying to make those married together. But I think it would be much easier for arbitrators, for judges, and for the users of arbitration if there could be reform. So I say the law reflects an ambivalence, but also probably the states, the attitude of the states, and their engagement in international arbitration. One of the earliest arbitrations before the ICSID was from Jamaica, the trifecta of cases, the Kaiser and Alcoa arbitrations. And in that trilogy of cases, Jamaica withdrew its consent to arbitrate in the natural resources sector and refused to, it disavowed the jurisdictional tribunal and refused to participate in the arbitration. Things have changed, but I just want to locate historically where I think the Caribbean was, and in terms of arbitration. And I think that this is, it might be understandable why these states have been ambivalent, particularly to international arbitration. For example, arbitration and international arbitration can be seen as foreign. There are ongoing debates about international arbitration being dominated by a few elites in the West. And it's difficult to show and to demonstrate for people in different parts of the world why a system which seems to be dominated by certain players, by certain concerns, is suited for them. Secondly, the modern infrastructure of international arbitration, including the New York Convention, came about long before these states existed as independent states. And they were not integrally involved in the crafting of the Constitution. And so, this is a part of the process of assimilating into the international community. And also the common law, historically, including in its country, had a natural skepticism for agreements that ousted the jurisdiction of the courts. And so there are lots of factors which may account for the skepticism. We can see, however, that in recent times that is beginning to change. And there has been a move from ambivalence, largely because of what I think I see as a promise of arbitration, the virtues extolled by Gary this morning, where international commercial arbitration isn't merely seen as a neutral mechanism for businessmen to resolve disputes, but it holds out a promise to developing states in particular of generating increased FDI. This is the mantra, and this is how it is sold. It is embedded in the architecture of international commercial arbitration and the discourses of international commercial arbitration. And I think it's this promise, the hope of economic development and advancement that has caused at least the states in the Caribbean to be turning towards a less ambivalent position in relation to international commercial arbitration. And it's interesting because we see, for example, the move, and Justice Anderson mentioned this, the fact that international commercial arbitration is enshrined in what I may call the economic constitution of the Caribbean. The Treaty of Chaguaramas, as Justice Anderson pointed out in Article 223, encourages states to ensure that their laws allow for international commercial arbitration and for the enforcement of arbitral awards consistent with the New York Convention. Though that has been stated at the level of aspiration in the Treaty of Chaguaramas, as is shown by Jamaica's legislation, they are yet to comply with that international obligation. However, notwithstanding the various colonial statutes, there are a number of legislative reforms that are underfoot, and a number of jurisdictions have recently reformed their law consistent with the model law. These have unsurprisingly been the offshore jurisdictions: Barbados, the Cayman Islands, the BVI, the Bahamas. Those jurisdictions have, by and large, reformed their laws consistent with the UNCITRAL model law and also the New York Convention. And as such, we see a move towards embracing and facilitating international commercial arbitration in the region. I will also add that there is presently a move underfoot to create a model arbitration statute in the region, which may hopefully serve as a template for the more recalcitrant states, such as Jamaica, to adopt legislation that is fit for purpose. But not only the legislatures that have been turning towards an embrace of international commercial arbitration, but also the judiciary. And I will highlight just a few judgments, including the judgments that have been highlighted by and penned by Justice Anderson. And I'll point to the British Caribbean Bank and Government of Belize. And in that case, there was a striking bit of dicta which underscored the CCJ's endorsement of international arbitration. And in that case, it said, investment treaties form an important feature of the modern economic jurisprudence, and they constitute an important developmental option for capital importing developing countries, such as in the Caribbean. The bilateral investment treaty was developed to remedy the vulnerability of the foreign investor and ameliorate the condition of their investments, and the success of the treaty regime depends on the acceptance and fulfillment by the host state of the legal obligations imposed by the treaty. And this is a very interesting case, of which I had the privilege of acting, because, as Justice Anderson explained, the party, the state of Belize, tried in that context to restrain foreign investors from bringing an investment treaty arbitration. And the court, the Caribbean Court of Justice, discharged that injunction on the basis that it was not vexatious or for the investors to bring that claim via BIT. But outside of the BIT context, in the context of commercial arbitration or contractual arbitration, the Caribbean Court of Justice has also given a very clear pro-arbitration stance. In Belize Natural Energy, they noted that arbitration is an increasingly preferred method of resolving complex commercial disputes, and that it rests on the key principle of party autonomy. Parties to an arbitration agreement make the conscious decision to prefer the prompt, expedient, and final settlements of their disputes through arbitral process rather than court proceedings. And it said that the court had a duty, and public policy supported upholding those agreements to arbitrate. And finally, the court has also, in the BCB case, also endorsed the fact that the court should be pro-enforcement under the New York Convention and should do all it can to enforce international arbitral awards, except, as the court pointed out, where it contravenes fundamental norms of the forum, including under the Constitution. So we've seen the legislative moves on the foot to change the law to reflect modern arbitral trends. We've seen a change in the judicial tenure in relation to international arbitration, including what I may say is one of the more far-reaching statements I've seen a court make in support of international arbitration. But not only have these states tried to do this legislatively and through their courts, but they're also trying to become arbitral centers, to set up centers for the settlement of international arbitration and seats for international arbitration. And so the Bahamas, for example, is trying to make itself an arbitration hub, and it's presently circulating a draft bill which is supposed to amend the current Bahamas Arbitration Act to set up an international arbitration center. The thought is that the Bahamas has strategic geographical placing, has a very well-established legal system, including for offshore companies and trusts, and therefore one of the natural extensions of the legal infrastructure is that the Bahamas may become a hub for international arbitration. The same is also on the foot in the BVI, and in the 2013 BVI Arbitration Act, there's a specific provision for the setting up of the British Virgin Island International Arbitration Centre. And certain commentators have started to surmise whether the BVI or the Bahamas or these offshore jurisdictions will be able to, for example, push London or Paris off their perch as a preferred choice for arbitration. Certainly as a preferred venue, but that is the idea. And obviously what these jurisdictions are doing, leveraging their status as offshore jurisdictions, and which hear and adjudicate various transnational complex commercial disputes that arise from the trusts and the offshore companies that are incorporated in there. This is clearly a move to diversify the legal offering and trying to tap into the economic promise of the business of arbitration.
So instead of sunny climes for shady people, it'll be sunny climes for arbitral people.
I think they'll probably find that some of them are equally shady. So that's the promise. That is the idea, that not only will the states modernize their international their statutes to allow and to facilitate international arbitration, but they could potentially become centers. The question is whether this promise of international arbitration, in terms of its economic promise, can be fulfilled in the Caribbean. There are a number of issues that I think that arise and which need to be addressed if this is to happen or is to have any sort of credibility. The first is the legislative framework. We've seen a big divide. It is a big divide from a 2012 International Arbitration Act, based and even improving on the model law, to a 1900 Arbitration Act in Jamaica. And I think one of the things that the Caribbean needs to look at is whether they should be competing as jurisdictions, which they obviously are doing now, and whether there should be a joined-up regional approach, as they did with the Caribbean Court of Justice, for example, in perhaps thinking of a regional arbitration center that pulls together on the strengths of the region, rather than various countries in the regions competing, trying through various regimes and various centers to get their piece of the arbitration action. Another issue that needs to be addressed, if one of these jurisdictions is to be a credible seat for international arbitration, is the issue of the local courts. What we see in the Caribbean is the apex tribunal, the CCJ, and for some countries, the Privy Council, being extremely pro-arbitration and being very quick to act to uphold international arbitration agreements and to enforce arbitral awards. However, at the lower rungs of the judiciary, there is work to be done. I found one case, for example, from the Barbados High Court, in which it took 3 years and 9 months for a court to decide whether an arbitration agreement called for the appointment of 1 arbitrator or 3 arbitrators. Just to wrap up very quickly, clearly, international arbitration holds out very many promises for Caribbean states. First of all, we know that international arbitration and a facility that allows for international arbitration helps to grease the oils of business. Moreover, there is another potential benefit in becoming a part of the arbitral infrastructure, in being a seat, a center, or potential venue. Whether this will amount to something in the future, I don't know. What I do think, though, is the core promise of international arbitration is helping to strengthen the rule of law. The Caribbean is a region with a lot of guarantees, rule of law guarantees, a strong judiciary that upholds constitutional rights. However, arbitration can fill the gap and help to strengthen what is already a pretty strong system. In my mind, the rule of law is not something that exists or doesn't exist. It is a work in progress for all societies. And there is one instance that, one case that I was able to work on, which underlines for me the strength of arbitration for underpinning and strengthening the rule of law. It is one of the cases we spoke about, the case of BCB, where one government, using its legislative and executive power, sought to stack the deck against an investor by constraining the investor from going to international arbitration. And I could spend the whole day speaking about it, but also amending the Constitution to ensure that an investor didn't have recourse to compensation after an expropriation. In that instance, international arbitration and the courts worked together to ensure that the parties at the end of the day had a just remedy. I don't see international arbitration in the Caribbean as being a substitute for the courts, but I think that the promise of international arbitration is that it helps to support the court system, and that work needs to be done to both promote international arbitration and the court system to ensure justice for businesses and for all in the Caribbean.
Thank you very much.